the whole truth, and nothing but the truth?
Yes.
Yeah.
All right, you may both lower your hands. Ms. Sweet, you may proceed.
Thank you, Your Honor. We are here on the state's motion to modify the the previous child support order. If I may give the court a brief background before I begin.
Yes, sir. Yes, ma'am.
Thank you, Your Honor. There was a divorce decree that was signed March 7th, 2024. In that order, child support was set to over $800. And then the state had filed its motion to modify child support 3 months later in June of 2024. A month following that is on file Mr. Brooks' motion to modify the support as well. And then, Your Honor, this court had signed the first temporary order on September 11th of 2024, and then signed a further temporary order December 12th of 2024. In those temporary orders, the first one was support based on a little over $2,100 of income. And then in the December 2024 order, support was based on a minimum wage. We're here today. The state is asking that this case be reset for May 29th of 2025 to receive information requested in the state's petition filed June 17th of 2024. That still has not been received by the state. And then I believe Mr. Brooks is requesting that we either do a final, and if not, then that this case be referred to the district court, considering his pleadings filed after the state's.
Okay.
In addition to that, if I may, Your Honor.
You may.
Okay, so the reason for my petition is based on Texas guidelines. If they do not have material evidence of a change in my income equating to $100 more or less, you guys cannot continue to bring me to court in perpetuity. The state has not presented that in now 3 hearings. Moreover, the state, I believe, has purposely tried to harm me by, for instance, when I made my initial petition to the court, which was done literally the first Monday after I lost my job. The court coordinator did not add my case to the docket, sent it to the Attorney General. Attorney General then filed their own case, because otherwise they had no evidence. Why would they have started a case for nothing? Beyond that, once that motion was filed, the information was not added to any of the preceding documents, despite being stamped and sealed and approved to be added. So at this point, there's no reason, there's been no material evidence or fact that would warrant this continuing in perpetuity.
What's your response, Ms. Sweet?
Your Honor, first, the state has no control over the court clerks as far as the filing that may or may not have been done in April of 2024. Secondly, there's a temporary order in place that's basing support on minimum wage now, so there's no harm to Mr. Brooks putting this back until May. And third, he's trying to benefit from not providing the state with information required to look to see whether or not it qualifies for a modification and whether modification is appropriate. And fourth, as I spoke to Mr. Brooks, he's not interested in the Choices program, and the court is doing these temporary orders and keep resetting the case in order to see whether or not Mr. Brooks has found any employment, to see where he is at in his employment status. And so, Your Honor, that is why the state is requesting that this case be pushed back again until May of 29th of this year.
Mr. Brooks, have you provided the state with any of the documents that they've requested?
They had the information. So if it was in June of 24.
Mr. Brooks, that's not what I asked you. That's not what I asked you. I didn't ask you what they had. I asked you what you provided. Did you provide them the documents that they requested?
There were no documents to provide in June of 2024. If I lost my job in 2024, they would have had the income that was there, which was what I was already on child support for. If it was June of 2024, there's nothing else to provide after I was terminated. I provided my unemployment insurance, but when I had my unemployment income, I provided that of my own volition. So that was the only information that was available.
They asked for a lot more than just salary information. They asked for income tax information. There are other things that they requested. What I'm asking you is, did you provide that information?
There's not been any request for that. If you're saying in June of 2024,
Mr. Brooks, it is in the pleading. What they request is in the pleading. It's not a separate request. It is all in the pleading.
I know we're talking about June of 2024, correct? because that was the only pleading. Other than that, it's just been temporary resets, correct?
That's correct.
Again, in June of 2024, the income that was provided would have been that. The tax documents they had, that was in my submission from what my income was previously, because that's what I needed to do to prove that there has been material evidence showing that there has been a deviation in what I was making to what I was currently making. Like, that's what I'm saying. So it went from, this is the income I was making, this is what the previous order was based on. This is no longer current because I've been terminated. This is the current income that I have. Anytime I've procured employment or lost employment, I provided that. There's no benefit for me to not do so.
Okay. Ms. Sweet, were the documents provided that you requested in your petition?
We don't have any of those documents, Your Honor, and I believe what Mr. Brooks is saying is that per the terms of the divorce in March, that's when the documentation was provided. The state wasn't an official party, although we did sign off on the divorce decree, and I do not see where any of that information was provided, or whether or not there was a trial that may have been provided to Ms. Brooks or her attorney at that time, but I do not see that we had any of those documents. Not to mention, if this had happened and the order was signed in March, then the income tax documents for the 2023 year may or may not have been even done at that stage. So not sure whether or not they were provided, but I do not see that they were provided pursuant to our new pleading in June of 2024.
Okay.
In
Then
the
I'm gonna
previous hearing,
reset this what'd you
I'm
say,
sorry.
Mr. Brooks?
In the
Go ahead.
previous hearing with Justin Dale, that was the information that he provided relevant to the case. So they have to have it.
Mr. Brooks, I mean, I don't know what they have and what they don't have, sir. I can just go based on what you guys have told me. I'm going to reset this to May 29th, Ms. Sweet.
Yes, Your
Is
Honor.
that what you guys are asking? I'm going to reset this to May 29th, 2025. I would expect all parties to give the documents that the states requested to the state, or come up with a reason why those documents shouldn't be given to them. Okay?
My thing is without material fact, because they can't continue to reset the case. This is now 4 times that we're continuing to reset this case, which is not because they don't have any evidence substantiating a reset. And again, we have a private order, so I don't understand why we're entitled to a court in the
my
first place.
ruling. This case is reset to May 29th, 2025.
Well, I moved that my case prepared in the district court.
8:30 a.m. And if you are objecting to their request for discovery, there's a formal way to do that.
Well, I want my case heard in the district court, not here. This is kangaroo court, and it's like,
Well, you can call it what you'd like, sir. And I'm not referring this case to district because there's no reason to refer it. There are no
if we have a private
extenuating
order,
circumstances. There are no extenuating circumstances that would justify referring this to district court. So
the case initiated in district court. Why
it
it
doesn't
came to
matter
title court?
where it initiated. The attorney general is a part of the case now. That's why it's in 4D. It doesn't have anything to do with where it's initiated, sir.
I do understand that, but the attorney general has already been a part of it. If we have a private order to be, I mean, I have a right to have it heard in district court, so I'll file my own motion. That's fine.
You do not have a right to have it heard in district court. And if you wanted it heard in district court, you would have had to have it referred to district court before now. Okay?
Which was in the motions that I filed that your coordinator did not put on the docket or accept. So that's fine.
Okay. I can't tell you that that did happen or that didn't happen, because as far as I know, the attorney general's filing was first, and that's why it was put on this docket.
So let me ask you this. So if they don't have any evidence, right, that settled the change, why would the attorney general just randomly file a modification? That's asinine. It doesn't make sense. They wouldn't just randomly file it. So they filed a modification to lower it. We know that's never the case.
You're arguing a point that is mute at this point because I've already reset this case. That's something we can argue when we come back, sir.
But you're not going to give me a chance to argue. We're going to keep this in perpetuity, violating all the guidelines.
We're not going to keep anything in perpetuity. I'm not going to keep resetting this in perpetuity. Well, I don't think it's unreasonable to reset this to May 29th. I might think it's unreasonable to reset it after then, but I don't think it's unreasonable to reset it this time because the documents have not been provided. Just provide the documents, Mr. Brooks. That's all you have to do.
That's what I'm saying. If I didn't work
They
in
will
2024,
tell
what
you-
documents are there to provide?
Mr. Brooks, the Attorney General will tell you what documents they're requesting. Do you want to go back in a breakout room with him, Ms. Sweet, to
No, I
tell
don't want to
you
speak
what
to them no more.
documents you need?
I'm done with this entire process. I don't want to speak to them anymore. You're asking
Okay.
for documents that do not exist. It was the
Okay.
same thing when she came asking for check stubs. I'm not working. What check stubs are we going to provide?
Mr. Brooks, if there are no
can't leave the court
documents,
with
you
the
need to
report.
turn in something in writing that says there are no documents. If there are no present or past income tax returns, no documents showing any income, no rental property, anything that they ask for in that discovery request, sir, just provide it or say I don't have it in a written form. That's all you have to do.
So in my initial answer, because they didn't, the way they
Mr.
did the
Brooks,
on the
I'm
record,
not going to keep talking to you about what you did before, okay?
but I'm saying the stuff you're asking for, I've already provided.
This case
It's already
is
been provided. That's what
reset.
I'm saying.
It's reset to
It's
May
already been
29th.
provided.
They say it hasn't. You
So
haven't
they
put
would have to
anything
prove that.
in
It can't just be
writing.
their word.
Okay, Mr. Brooks, we're going to reset this to May 29th, 2025 at 8:30 a.m. You will need to be present on that date and at that time. If you're not, a default order can be entered against you, okay?
Whatever, man. It doesn't make sense. Like they have whatever, man.
Any questions, ma'am?
I just want exactly what Attorney General is asking for the documents to be provided as far
That's
as.
something they will have to tell you, ma'am. Okay?
Yes, ma'am. That's all that I had.
Okay. Any questions from you at this point, Mr. Brooks? Not a statement, any questions?
I understand that, and I think I asked you that last time. Like you can just ask the question because I don't like the condescension. So this is my thing. I would like to request a written copy of this proceedings here. I don't know if we actually got on the docket, but we were sworn in, so it should be written. I would like to request that within the next 72 hours.
You can request a transcript of the court reporter, but you have to pay for it, sir.
That's fine. I fill out the form I had to waive.
All right.
Yeah.
Anything
Are
further?
we good to go?
Yes, if there's
Can I-
nothing further, you're both free to, excuse me, ma'am?
Can I ask you a question, Judge?
Yes, ma'am.
As far as the resetting for May 29th, we'll get the time and things in the mail like usual.
That will come from the Attorney General's office, yes, ma'am.
Okay, and on that, we're asking to request for documents as far as his.
You would have to ask the Attorney General what they're requesting. Okay?
Okay.
All right.
Okay, because like you said, or like it's been on document, it's been the third time. So I'm definitely open to making sure that we get everything we needed for the case. And I appreciate you seeing the case today. Thank you.
Anything further?
No, ma'am.
Anything further, Mr. Brooks?
It's not going to be taken into consideration, so that's fine.
Okay, sir. It's your
They
choice.
have everything. Otherwise, we wouldn't be here.
Thank you both for appearing here today, and you're both free to go.
Thank you.
Mhm.